This is Michael Popok, Legal AF. I am sure you've heard that the Colorado Supreme Court in a 4-3 decision banned Donald Trump from the ballot. But let me explain what that means and why Donald Trump is going to be on the ballot for the Republican primary in March and what happens next at the U.S. Supreme Court, because that's the next stop on the train. The Colorado Supreme Court 4-3 decision finding that Donald Trump was engaged in insurrection or rebellion against the Constitution as a former federal officer who was sworn to uphold, or in this case, support the Constitution. That decision, and allowing the Secretary of State of Colorado under a line of cases once presided over by current Supreme Court Justice Neil Gorsuch, a case called Hassan, which said that states have the right to control their own political process and exercise their own rules for the integrity of the system. That whole issue, that whole Gorsuch tainted issue, is on a fast track to the U.S. Supreme Court, a fast track created by the decision itself by the Colorado Supreme Court. Because buried within the decision and getting very little publicity is the fact that they have agreed in the order, the majority, to stay the application of the order. In other words, to block their own ban of putting Donald Trump on the ballot until the U.S. Supreme Court weighs in, as long as Donald Trump files an appeal in his appeal papers with the U.S. Supreme Court by the 4th of January. The 5th of January, the very next day, is the day that the Colorado Secretary of State has to certify who's on the ballot for the primary in March. And because the ban on Donald Trump will be blocked by this order itself, while the Supreme Court of the United States takes a look, that means Donald Trump's going to be on the ballot for March 100%. So don't be shocked when you read Donald Trump won the primary in Colorado in March for the Republicans. Some people might think, I thought he was off. He's not off because this particular order is self-executing to block the ban during the pendency of the appeal. Now, what happens at the U.S. Supreme Court level now that they take a look at this 213-page decision, which was, and this is no surprise to anybody, it was voted 4-3, 4 Democrats on the panel on the Colorado Supreme Court ruled that the Donald Trump engaged in insurrection or rebellion under Article 3 of the 14th Amendment, banning him from the ballot as an insurrectionist and a person engaged in rebellion. And the dissent were all the Republican judges on the Colorado Supreme Court. Let's talk about the dissents for a minute. It breaks down into 2 major categories. One of the dissents was that under their interpretation of the reading of the 14th Amendment, although these words are nowhere to be found in the text of the amendment, is that the requirement that there be an actual criminal conviction, a charge and a criminal conviction of Donald Trump for insurrection or rebellion. Now, Donald Trump's been charged with a lot of things. In fact, he's been charged with 91 felony counts, but not one of them is insurrection or rebellion. To come close, we've got criminal interference with an official proceeding in Congress. We've got conspiracies around that. We've got different levels of obstruction of justice, but not insurrection and not seditious conspiracy and things like that. And this particular dissenter, one of the people that voted against the majority decision, said there should be a conviction. Now, if you look at the 14th Amendment, and I've already posited it in prior hot takes and on Legal AF, there is not a requirement for conviction because the founding fathers, or in this case, the framers of the 14th Amendment after the Civil War, knew it would be virtually impossible to have trials and convictions. It would rip the country apart of former Confederate leaders and then use that conviction to bar them from future office. Things were moving very quickly during the Reconstruction period in America, led originally by Abraham Lincoln before his assassination and then continued on, and they weren't going to add this extra layer of let's have a trial and conviction and that'll keep him off the ballot if he was an insurrectionist or engaged in rebellion, i.e. the breakaway republic from the United States in the form of the Confederacy. Not in there, not in the language of the legislative history around the 14th Amendment, but to this dissenting Supreme Court justice in Colorado, there should be that requirement. That's one. The second group of dissenters fell into the category of, this is a very interesting issue about the 14th Amendment, but it should be decided by Congress. The United States Congress should decide who can and can't be on ballots, not each individual state. And that's an argument that Donald Trump has raised as well. We've seen this in other analysis, in Michigan and Minnesota, where this attempted ban on the ballot was tried there too. And that's kind of the common off-ramp for some of these justices that don't want to get into the middle of the political question of whether Donald Trump is eligible to be president or not. So they say, Congress, it's Congress. Let Congress handle this. And there's no case law that suggests that judges and courts in states, especially under that Hassan decision, that legal precedent that Neil Gorsuch, when he was on the 10th Circuit Court of Appeals, before he became a Supreme Court justice, ruled on, which said, in effect, that states have the right to protect the integrity and functioning of their political process, including who's on and off the ballot. Well, now we'll have to see what now Associate Justice Neil Gorsuch says, now that he's in the majority on the right wing of the U.S. Supreme Court, and see if he changes his tunes. He's going to have to decide and could ultimately be one of the people chosen to write the majority decision. This is a big problem ultimately for John Roberts, who spent the last, 20 years trying to instill confidence in the legitimacy of the Supreme Court. And of course, that hasn't been happening as of late, especially since Trump's been in office and all of the decisions like the Dobbs decision, ripping away a constitutional right for a woman to choose after she'd had that right for 50 years. Note to John Roberts, that doesn't help with the integrity of the justice system. And now Roberts has a new problem. What does he do with this particular issue? It's the same constitutional crisis and legitimacy crisis that we saw at the U.S. Supreme Court in 2000 when they were forced to decide or intervened in Bush versus Gore, that flip of a coin election in which Al Gore appeared to have more votes than G.W. Bush, came down to Florida. Florida had ruled for Gore, and that would have given the election to Al Gore and the rest of history, and the trajectory of history would have changed. Imagine if we didn't have George W. Bush in office and all of his disastrous foreign policy and war forays. Put that aside for a minute. That election was not decided by 300 million people in America or by the Electoral College. That election was decided by a 5-4, one justice vote on the U.S. Supreme Court after less than a week of briefing and oral argument. That's how we got our president, President Bush. Within 72 hours after the Florida Supreme Court ruled in favor of Gore, the U.S. Supreme Court reversed course, said the Florida Supreme Court was wrong, ballots that they counted shouldn't have been counted, and ended the election right there and gave it over to George Bush. That's it. Big headline, New York Times. Supreme Court, 5-4 decision. Awards the presidency to George W. Bush. That's how that happened. And this is now, Roberts wasn't on the Supreme Court at that time, but this is now Roberts and his legacies, Bush versus Gore. Because now, instead of Florida, substitute Colorado. And now you have to decide whether the Supreme Court wants to get involved with that unsavory task, which they see as very political, of taking the issue away from voters. Now, people that are watching this hot take might say he's an insurrectionist and he engaged in rebellion, and so technically he should be off the ballot, and people in Colorado should not be voting for Donald Trump. There's also the political aspects of this, right? If Joe Biden wins and wins by a lot, this is a non-issue. If Joe Biden wins, but it's only because Trump didn't have his name on the ballot in Colorado, then we've got some problems. Jan 6th attacking insurrectionist type problems in this country. And the Supreme Court, I'm sure, is mindful of that. There's many ways once they get that appeal, and they're going to get it on the 4th of January. And I'm sure they're going to set an expedited briefing schedule because it's that important. They can do one of two things. Let me back up on that. They can do one of two things. They can set an expedited briefing schedule that I think they should do, and then put this thing before the March ballot, and then give instruction to the Secretary of State of Colorado to take his name off the ballot if they rule for Jack Smith, ultimately, or rule for the Colorado Supreme Court decision. Or they can just go normal course. They set their own time. They make their own decisions. They don't move any faster with more velocity or less velocity because anybody wants them to. This is how the Supreme Court operates. So they could just sit on this, let the March primary happen with Donald Trump on. He'll get the nomination and then deal with it over the summer or as it gets closer to the election, use one of their guiding or doctrinal principles and say, oh, we're too close to the election. We just can't take away the voters' right to choose. And so this particular election is going to go forward with Donald Trump on the ballot. That's a likely scenario. The other thing that Roberts can do, and I want to be the focus or the thrust of this hot take, is what he can do to try to compromise between two different decisions, but interrelated decisions that are up at the Supreme Court at the same time, and try to broker, and yes, they brokered decisions, especially the Chief Justice, getting votes on one as a trade-off against another major issue that's up there. What are the two issues I'm talking about? On one hand, you've got the U.S. Supreme Court ultimately going to decide whether Donald Trump has absolute immunity as a president at the time, now former president, from criminal prosecution relating to his actions when he was president, especially when he was impeached by the Democratic House, but wasn't convicted by the Republican Senate about certain related issues, overlapping issues that are in his indictment. That's an issue that's now front and center with the U.S. Supreme Court. They said they weren't going to take an emergency direct appeal, but they are going to have the appeal brought up to them once the D.C. Court of Appeals makes its ultimate ruling, the 3-judge panel there, which is Judge Pan, Judge Childs, both Biden appointees, and Judge Harrison, who's a G.W. Bush appointee, ironically. Once that panel, in a majority decision, makes its ruling after the January 8th oral argument, so let's say the 10th or 11th or the 12th, the loser is going to appeal to the U.S. Supreme Court, who I assume is going to put it on a fast track. So on one hand, you've got Roberts trying to get votes to decide whether Trump has immunity from suit, at the same time that Roberts trying to get votes to decide whether he should be barred from the ballot as an insurrectionist. And this decision by the U.S. Supreme Court is not just about Colorado. Remember, Minnesota, Wisconsin, Michigan, and various other states have tried to ban him from the ballot under the same 14th Amendment as well. And once they make this definitive ruling, the U.S. Supreme Court, one way or the other, thumbs up or thumbs down, it's binary. You either can or can't ban him from the ballot. And so if they decide this is the brokering going on, this is the handling going on, right? Roberts gets the votes to say that he can't be banned from these various ballots, Donald Trump. At the same time, in trade, he gets the votes so that he gives Jack Smith the win, that there's no absolute presidential immunity that would stop the indictment. You see the trade? See the cigar smoking, back-filled, cigar smoked room thing that's going on here? I don't know why I butchered that particular phrase. You see what's happening? Roberts, Chief Justice, is going to the justices, 6-3 MAGA right-wing majority, and saying, I'll give you that he's not going to be banned and the voters can vote for Trump in 50 states. You give me that there is no absolute presidential immunity for somebody who's been indicted for being a criminal in his cling to power. And that's what we're going to watch here on Legal AF, on the MeidasTouch network, and on hot takes like this one about every hour in one place. This is where we do it. The MeidasTouch network, helping them get 2 million free subscribers by just clicking. That's all you got to do. And then you can watch our full 1-hour curated podcast at the intersection of law, politics, and justice we call Legal AF. It's exactly what you think. It's on Wednesdays and Saturdays at 8 p.m. Eastern time. And then if you like what I'm doing, Michael Popok, give me a thumbs up. Give me a comment. I've been known to comment back. We'll open up a dialogue. It helps with my ratings and keeps me on the air for hot takes just like this one. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.